very excited to be joined by Rick Swedloff today. He's going to be sharing his paper, Insurers as Contract Influencers, with us that he co-wrote with Dave Hoffman. And before turning it over to him, I'm just going to preview the next session. So in 2 weeks, we'll have Roy Barahad, who's a PhD candidate at the University of Chicago, talking to us about his paper on reliability insurance. And so with that, I'll hand it over to Rick.
All right. Thank you, Travis, and thank you to the Insurance Law Center, and thank you to Peter, and thanks generally for hosting this terrific series. It's nice to have a place to listen to people talk about insurance at a theoretical or a slightly higher theoretical level. It's been great. All right, insurance as contract influencers. I want to start with a claim. The claim generally is that contracts are proliferating. In the last 30 years, the number of contracts that consumers have to sign has just skyrocketed. Are you opening a new app for the first time? Are you joining a fantasy sports league? Are you checking into a hotel, a trampoline park? Are you simply using your phone and updating the iOS? You probably have to sign a contract. This, as Dave has called it, is the empire of forms. And I think it's relatively uncontroversial to say that there are more contracts today than there were. The smaller version of the claim, litigation derogating terms, are extremely common in the empire. What do I mean by that? Well, what I mean by that is that there are a number of clauses that effectively strip, limit, or control the right to litigate claims. Here, we might think about things like covenants not to sue on the strong side, or waivers of liability, which inhibit the ability of injured parties to sue more generally. You might think of, sort of on the medium side, but still on the relatively strong side, class action waivers, arbitration clauses, or something even slightly gentler like choice of law or choice of venue clauses, which keep potential plaintiffs away from plaintiff-friendly jurisdictions, or at a minimum, simply add predictability to the litigation landscape. If the first claim, that there are more contracts, is uncontroversial, I would say that the second one is mostly uncontroversial, though the evidence for the second claim is impressionistic at best. We know that there are more arbitration clauses than there were, and that these clauses are on the rise or are at their peak now. Maybe they're ebbing for reasons we'll talk about in a moment. But we know far less about the prevalence of choice of law, choice of forum, anti-class action clauses, etc. Though it stands to reason that if there are more contracts, and those contracts generally have boilerplate, at least some of these contracts, contractual terms, are more prevalent than they were 30 years ago. What do we know about these contract terms? Well, everyone basically agrees that they're not read, that they're not precisely priced, and that they're not going to be interpreted consistently by courts. So when I say they're not read, I mean, I think this is fairly obvious. When was the last time when you had to click through a contract, you spent time to read through every term? The pricing we'll get into in a moment, and the interpretive problem is something that that also we'll talk about later in the talk. But the clauses present two relatively big puzzles. The first is, are they any good? Are they good or bad? And the second is, why is it proliferating? Why is boilerplate just spreading, and who is doing the spreading? Where do they come from? What do I mean by good or bad? Well, by good here, I mean that in some version, some people have claimed, without evidence, I should say, that nuisance litigation is a scourge on the earth, and that these clauses generally drive down the number and costs of nuisance claims. And because of that, the consumer is going to be better off. Why? Because the firm that is producing
Did we lose Rick?
Seems like it.
Okay, Travis, you introduced him. You can pick up from here. Just keep going. Oh, no.
Okay, wait, I'm back.
Oh, great.
I'm
Thank
back.
goodness.
I'm sorry. Okay, I need to share again. Sorry, everybody. I don't know where I lost you all.
You were at good and bad. That's the
Okay,
slide.
well, let's get back there. Okay.
Yep.
We're doing it. All right.
Okay, welcome back.
Thank you. Sorry, y'all. Okay, so what do I mean by good and bad? Well, in one version of this, nuisance litigation is a problem. It generally is just costly to firms, and anything that helps curb nuisance litigation is going to be good for consumers. It's going to be good for consumers because it will be cheaper to produce the goods, and either that means that those savings will be passed along to consumers in the form of lower prices or in terms of better products because the firms will invest in research and development. The other claim, also basically unverified, though feels better in our hearts, is some version of boilerplate is bad. It's bad because no one reads the contracts, and most people can't really price the value of the contingent and highly variable terms that these boilerplate clauses are providing, right? So that is, no firm can compete by saying, hey, we're not going to eliminate your right to sue us if something goes wrong, because people don't necessarily care about having the right to sue. And even if they do care, and they won't know that other firms are taking away that right. And even if they do know that people are taking away the right to sue, for instance, if there's a great marketing campaign by a firm that didn't want any of these terms in their contracts, but also didn't want their competitors to have the terms, most people would have a difficult time putting a price on the value of the ability to sue, or sue in a class action, or sue in the venue that they choose. The other part of bad is sort of a proceduralist concern, which we won't really concern ourselves with here, but it's that by putting things in arbitration, we're hiding from view important developments in the common law and public shaming for negligent or bad actors. And by stunting the common law, we're creating a public problem. But that, as I say, is a different set of problems. But in truth, we don't actually know what's going on. We don't know because while people continuously claim that boilerplate is creating savings, there's little direct evidence of that. There's some idea, for instance, that arbitration clauses generate savings, but it's weak at best. The best study on this by the CFPB a couple of years ago basically threw its hands up at this question in terms of whether there's real savings. There's lots of claim among lawyers on the ground that choice of law, choice of forum matters, but there's no real proof that these clauses are affecting the firm's bottom line in terms of stock price or in terms of profits. There's really no studies on the class action waivers, and absolutely nothing on exculpatory clauses or the liability waivers. So without studies showing some actual benefit or something real, we're a bit in the dark. We're similarly missing a story about the production of these terms in the consumer context. We have some evidence of boilerplate drafting in commercial settings, but we don't really know much about the generation of these boilerplate terms on the consumer side. And to the extent that we do, GCs at these big consumer firms have basically said, we do not have time to be monkeying around with our contract language. We're way too busy dealing with everything else that is on our plates. So it's very unclear. And given that, Dave and I had an idea. Shouldn't insurers know a little bit more about this than the rest of us? Liability insurers have lots of reasons to know generally what's happening in the litigation world. They're repeat players in litigation, and they are responsible for some of the litigation costs, including attorney's fees and damages, if there are such. And because of that, they're deeply motivated to figure out what causes loss, or at least their covered losses, and how to minimize it, right? And because they know something, the other thing we know is that insurers have some tools to do something, right? If it is the case that insurers think that boilerplate saves money, we know that they have tools at their disposal to encourage adoption. Specifically in this context, the three tools that we could imagine, or that are most prevalent, are they could offer price breaks for adopting boilerplate. They could refuse cover to policyholders who want cover but don't have good boilerplate, and they could try to educate and jawbone with their policyholders or with applicants about the value of boilerplate, both at the initial phase when policyholders are applying for insurance and at a renewal phase. All right, maybe an example might help to sort of understand what I'm talking about here, right? Consider this country's many trampoline parks. People go to these parks to jump. They jump high, they jump frequently, and they do, as this child is doing, flip over onto their necks, right? And because of that, they get injured pretty frequently. That means that trampoline parks are exposed to liability, and derivatively, so are their insurers. And we had a thought. Perhaps those insurance firms might have a chat with their policyholders and suggest to them how one might reduce their expected liability by writing enforceable and targeted waivers, which might make it less likely that their jumpers will win in a tort lawsuit. They might sort of find that the use of arbitration tribunals is better. They might think that a particular forum is less likely to give a big verdict. And once in a while, they might educate their policyholders about developments in the law, about choosing particular state law that makes sense, or about waiving class actions, et cetera, et cetera. And as a carrot for doing so, they'd give the parks premium breaks for adopting the provisions in their consumer click-through contracts that you have to sign, the waivers you sign when you go to jump. Or as a stick, they could deny coverage in the absence of a particularly important clause. And that's but the only way to find out is to go and talk to insurers, and that's just what we did. We went to the field and asked people in the insurance industry what they're doing and what they thought about consumer-facing boilerplate. We talked to approximately 24 insurance professionals, 5 brokers, 7 lawyers, 7 underwriters, 3 claims professionals, 3 executives. It's mostly a convenience sample, and we did so in semi-structured interviews, meaning we had a protocol that we started with, but generally the conversations meandered based on the experience and the interests of the interviewees. By the way, we are still interested in hearing from more folks. I know this is a mixed crowd, some people that are in the industry. If you know of or are a person who has information about liability insurance and you think that they would be willing to talk or you're willing to talk, just let me know. I would love to, I'd love to hear from you. All right, so that's the setup. It's a lot of setup. Here's what we found. We found first that Insurers think that boilerplate is valuable. They think that's true in large part because the respondents were really clear. They think that jury awards are a huge problem and they want to avoid American juries basically at all costs. To be sure, this is a long-running trope of the insurance industry. They've long been wary of the litigation system and have been vocal supporters of tort reform as a way to curb what they think of as jury excesses. But they view the current litigation environment equally as sort of with equally concerned eyes. They think that current jury awards are a tax on society that amounts to approximately 2.5% of the GDP. I haven't dug into how they got those numbers. What matters is not the truth of the matter asserted, but merely that they think that this is true. And basically, they think that juries are out of control. They think that jury awards are part of what they call social inflation. They think that awards are outstripping the cost of inputs. They think all awards should be increasing because inflation is increasing, but jury awards are increasing faster than other kinds of inflation. Why? Why do they think this is happening? Well, they think that juries are increasingly populist, willing to give out money against corporations, and they think that litigation funding is making a voracious plaintiff's bar more eager and more willing to take even mediocre claims all the way to a jury in the hope of getting one of these juries that's willing to provide a large award. Excuse me. So given that, it's not surprising that insurers think that boilerplate is valuable, right? With contracts, right, this is what one claims professional said, with these contracts provisions being a component of risk management that benefits the policyholder in securing the best possible deals from their insurance company. Right, so regardless of the truth of the claims about populist juries and juries out of control, they think that boilerplate that helps avoid juries is a valuable part of a risk management package that will enable policyholders to get a better deal from the insurer. This is especially true when boilerplate is part of an insurer's industry's best practices. If trampoline parks have regular checks of the facility for appropriate spring tension, for padding, for sprinklers, and additionally, all trampoline parks have a set of boilerplate waivers. Insurers evaluating whether to cover new trampoline park will look to see whether the new client is keeping up with industry standards. As one underwriter told us, there's an interactive relationship between what best practices are deemed to be for you to be a risk that someone is willing to insure. It also overlaps with the historical experience of the industry. Right. Okay. So we know that they like it. We know that insurance, we know that boilerplate is important. We know that it's especially important when it's part of the best practice of an industry. What do insurers do to try to encourage the use of boilerplate? Well, the first thing they do is they say that boilerplate might affect insurability, right? That is, boilerplate as a package of loss avoidance devices might be part of a decision about whether to provide coverage. Okay, so on a straight consumer level, I don't think it impacts underwriting for prices, but it might impact whether they offer coverage. Sometimes carriers will ask for contracts, especially depending on the complexity of the risk. As part of the underwriting process, insurance companies have built into their guidelines that they won't insure someone that doesn't follow best practices. So if the best practice of a bowling alley is to have a series of waivers or conditions around you bowling in their bowling alley, and you don't do that, well, the insurance company would probably not even insure you, let alone charge you more. This is especially true. One more. This is especially true in a post-claims environment, where non-renewal So if an insured has a claim and the claims professionals and the claims attorneys are going through their claim, it might affect the insured is at a particularly vulnerable moment. And what one claims professional told us is that I think if I didn't tell underwriting about the unsuccessful boilerplate language, my guess is they would just not renew the account. We'll never make our money back. But sometimes, if claims are talking to underwriting, they might renew that account knowing that the insured has done something. They're taking into account future risk and trying to lessen that risk for future claims by tightening up contracts. That is, at this one moment where often people are going to get not get renewed, you might get a lot of traction around changing contracts by threatening non-renewal.
Rick, can I just jump in with a really quick question?
Yes, of course.
Did you talk to them about whether they ever got pushback? I mean, if nobody reads these things and I'm running a bowling alley and my insurer says, hey, you should put in this language, like I'm just going to do that because I'm confident that they're just going to get their shoes and go bowl. They don't care what's in it. So why would anybody ever say no?
I don't think in the straight consumer context you see a lot of pushback. I think that's exactly right, because as I'll say later, it's a super low cost way of doing risk management, as opposed to if you run a bowling alley, like actually washing the shoes instead of spraying that disinfectant in there, or having tighter restrictions on how much alcohol is served, which might hurt your bottom line. This is a really low cost way to prevent loss. I think that's right, Peter. Okay, so the other, does that answer the question?
Yes.
I'm assuming yes.
Yeah.
All right. So the other thing that might happen is we saw that evidence that good contract language in consumer-facing contracts could affect price, right? At a renewal for one client, the pricing went up significantly, and the carrier had been harping on, okay, you need to implement this language again, hold harmless indemnification language in your contracts with the third parties. And the client said, yeah, we'll do it. But then from the losses that we see, clearly they haven't done it. So they had a significant increase in premium. We heard others say that there are modest changes in price related. There could be modest changes in price linked to anti-litigation contracts. But I want to be very cautious about this, and I don't want to overstate it, in part because the contractual savings might be relatively small compared to other types of loss prevention. Consider here something like cyber insurance, right? Lots of what's covered in a cyber policy is unrelated to a consumer contract. It might be related to contracts that a provider has with other big businesses, or they might be about ransomware or something like that. And even if it is related to consumer-facing, to consumer contracts or the relationship between a provider and their consumers, contractual savings are likely to be minimal compared to avoiding a ransomware attack or something like it in the first instance. And so underwriters and brokers seeking to manage price and risk focus first on technological defenses like two-factor authentication, for instance, instead of contractual language. Only after that do they really consider contract language, and even then it's a second-order concern, right? So this quote says it all. We look for things like limitation of liability, waiver of warranties, implied warranties, your kind of basics, but we don't really make a big deal of it. Yada, yada. But I also wouldn't say, while we care, I wouldn't say it's a big underwriting factor for cyber. Right. Moreover, insurers are generally skeptical about the enforceability of a lot of these clauses. Contract scholars, so Hoffman is a contract scholar, and he continued to tell me, no, these are enforceable. And I was like, okay, that's not what our respondents keep telling us. Folks on the ground were generally unsure about whether boilerplate was enforceable at all. Multiple respondents suggested that the clauses were unlikely to hold up in court. Again, I'm not here to debate their beliefs. I don't know whether the clauses are legit, whether they're going to be upheld, but the fact that respondents repeatedly asked whether they were enforceable or suggested skepticism at least gives you some instinct about why they might be suspicious about pricing or giving a lot of pricing breaks based on these clauses, right? So, but we and the underwriters also know that no waiver is bulletproof, especially in certain jurisdictions. If there's a clever plaintiff's lawyer who can come up with an argument, the waiver was unconscionable, the print was too small, it wasn't conspicuous, they're going to get thrown out. Because the underwriters know no waiver is bulletproof, and they still, that's a typo, they still have to underwrite the real risks. Right. So, and this was me sort of asking a different broker that question back. Okay, I'm just going to say it to you. One of the things you might be saying to me is the underwriters care about these clauses, but at the bottom, they're probably not going to give you a huge discount because of the clauses, because what they're really looking at is the underlying risk. They're fundamentally skeptical of the enforceability of most of these clauses. Is that fair? That's fair, said a broker. Right. Nonetheless, they thought that the clauses might be valuable. One last said, courts don't like boilerplate language. They feel as if you're trying to sneak something past the goalie, or you're trying to put in a provision that's so general that it would cover almost anything and everything, which really falls under negligence, and the court doesn't like that. Nonetheless, this same respondent told me that they thought the clauses might be valuable in other ways. Right? Why do we do it as an industry? Basically, it's a false stop sign for the unsophisticated to know what they have. They think that these clauses are going to prevent some set of unsophisticated consumers from bringing lawsuits. And that might be valuable in and of itself, even if the clauses aren't enforceable. Lastly, right, there is some concern that pricing is generally really messy. Respondents complained to me typically about hard markets and inflation, and said that all of those things are affecting liability insurance prices pretty significantly. And so they weren't out there giving price breaks for good boilerplate, but it might help sort of generally in some unsubstantiated way in the way we think about this person as a risk, or generally whether we're going to be conservative or not in our pricing as we compete in the market for this insured. So I don't want to overstate pricing as a thing, but I do think that it has some small effect on that is, insurers are using some small amount of pricing to encourage boilerplate in the marketplace. Lastly, we also saw lots of evidence that insurance professionals are trying to educate their policyholders about the value of boilerplate. Underwriters told us time and again that they put on road shows and seminars for brokers to explain to them the value of specific clauses in specific industries, and the construction industry and other consumer industries. And they said, we are out there pitching, among lots of other things, that boilerplate is one way to control loss. And we know that brokers have reasons to care. They care because sometimes they sell risk management services as part of what they're offering to policyholders, either explicitly as a separate product or implicitly as part of why it is useful for the policyholder to use them as a broker for their insurance needs. And also, we think brokers might care because ultimately they are judged in part on the profitability of their book of business. And so if boilerplate is helping reduce losses, then brokers might want their policyholders to implement boilerplate so that their book of business is more profitable. And we know policyholders are hearing some of that, but they also sometimes, and they are adopting language. Sometimes it's good, sometimes it's less good, and sometimes they have claims. And when they have claims, we know, I should say, one thing that brokers also told us is that they are hesitant to offer advice sometimes because they aren't lawyers. And In fact, in the UK, some of the respondents told us that they were explicitly, underwriters and brokers told us they were explicitly not allowed to offer particular advice about what clauses or what their policyholders should use. But those same brokers and same underwriters told us that they might nonetheless suggest that they talk to their own lawyers and then tell them what clauses to look at and what kinds of things they should have their own lawyers look at. So they're not offering advice, but they're suggesting they ought to get advice about a thing in particular. So then if policyholders have claims, we know that claims people are providing advice about avoiding loss in the future. And boilerplate was part of the story. So they are communicating back to policyholders and sometimes also to underwriters saying, look, here are what we're seeing about why losses are growing. Here are boilerplate clauses that we think would help minimize and why. And then underwriters are incorporating that into the next set of information that they're giving to brokers. And so there is an information ecosystem that we're charting through our respondents. What are they saying? So we know that they care. We know that they're giving signals. What are the kinds of things that the insurance industry are saying to their consumers? Well, first, they're saying we generally love exculpatory clauses. We like clauses that limit liability or transfer risk to another entity. That is universal. We are somewhat, we heard lots of things about our arbitration, but they were cross-cutting. They were somewhat ambivalent about the value of arbitration clauses. On the one hand, some respondents told us that they worried about arbitration because arbitration fees were expensive, and they often thought that that arbitrators were more likely to give at least some recovery to plaintiffs that get to arbitration rather than denying what they saw as truly nuisance claims like a judge or jury might. Others worried about rising costs and the rising tide of mass arbitration. So on the one hand, these are reasons that arbitration is bad. Again, I'm not here to tell you whether it's true or not. I'm just telling you what the insurers are sort of telling us. On the other hand, some said that they liked arbitration because it was faster and it was a little bit less expensive to get to a result. And they liked it because they think insurers tended to like having an answer rather than a question about how much is owed. They like to resolve, they like certainty over uncertainty so that they can clear up their books and help their reserves, help settle what their lost reserves are going to look like. They were generally pro choice of venue, choice of law clauses. One said, forum venue is quite important, particularly in a notably plaintiff-friendly jurisdiction. So in a jurisdiction like Philadelphia, we'd like to see a choice of venue, choice of law clause, getting the claims settled elsewhere. One claims professional told us, sometimes I would love to see a contract. I see a contract and I wish the contract said choice of law was Illinois versus Missouri, but we probably don't go back and try to push people to change. And I'm guessing the underwriters don't do that either, right? So they like it, but it's not clear how valuable it is in all circumstances. Class action waivers, we have to throw up our arms. I don't actually know what is going on. We didn't really hear enough about it. I think it's partially because there's a mismatch between the causes of action that give rise to class actions when boilerplate operates and where insurers govern, right? So for example, while insurers offer coverage for securities and corporate claims, D&O insurance, consumer boilerplate doesn't limit those claims. And Baker and Griffith have shown that insurers don't meddle to that degree in corporate loss prevention, right? So or we could think of something like breach of contract for a credit card problem, right? Or a banking situation. Insurers might think that they're not responsible for those claims because they don't cover breach of contract, and therefore they're not as worried about class action waivers. Okay, so that's what they're saying. But there are real limits to our claims. Our claim is fairly narrow. Insurers encourage and sometimes require the use of contractual language limiting liability. I'm not claiming that they're the ones who invented boilerplate language, and they aren't the sole source of its propagation, but they see it's valuable. Why can't we say more? Well, we can't say more for a bunch of reasons. The first is that there might be lots of reasons why the liability that might be controlled by boilerplate is partially or wholly uncovered by insurance, right? So it might be that there are small value claims that, sorry, right? So the basic point here is that insurers only care about that portion of the risk that they cover. And there might be small value claims or that are part of the insured's retained risk. So if a trampoline park has a high retention, then broken arms aren't really the problem. Broken necks are. There might be, right? So there might be retained risk. There might be some industries that choose to go bare to control the primary layers for a variety of reasons. Here, Tom Baker has shown that pharmaceutical and medical device companies are taking all of their risk at a primary layer in-house. They're offloading some of the excess, but they're then controlling that risk, and the excess layers aren't going to be as concerned about the contract language. Or it might be contested grounds. So go back to the contract example I gave you earlier. It's unclear whether breach of contract will be covered in any particular case. I mean, in that situation, we don't think insurers are as likely to push boilerplate. They might also be willing to offer more advice with bigger risks. So in some situations where the risk is quite small, right, if you're insuring a boutique hotel rather than Hilton hotels, it's less likely that you're going to get the kind of sustained and focused look at your risk management techniques. For a boutique, there might be a check the box part of an application process that says, do you have these boilerplate terms? But there won't be an actual review of your contract language, and there probably won't be as much time to get feedback on what could make it better. So there are some risks that just won't get the kind of advice that others do. Lastly, we probably can't say more because pricing signals are blunted and messy. As I said earlier, if boilerplate is a small factor of loss mitigation, it might not be worth sending loud signals to encourage adoption of the clauses. And if some insurers don't think boilerplate is valuable, but others do in a particular marketplace, then you can't really price based on boilerplate because other insurers will just undercut you. And if an insured says, we don't care if you want us to adopt the boilerplate because this other insurance company won't, then your threat to not cover won't be very meaningful. So pricing is a really messy signal. And lastly, as I said, the reason that I don't think we can say more is because insurers seem to be really skeptical about enforceability for some of the stronger clauses and about their general value. Okay, so from our perspective, that's all fine. Like, it's okay to have a limited claim. Recently, a lot of scholars, and I don't know if any of them are on the line, but have started arguing about the value of the insurance as governance literature. This is a long literature that includes me, but mostly Tom Baker and a bunch of co-authors, but Shaheen Talesh and others have written about insurance as a private governor of private industry. And recently some scholars have said that the governance crowd, including myself, have overstated our claim. I don't really think that's true, and I don't think we have to get into all of that now. I think we've mostly been careful about suggesting the limits of our findings, and as here, I think we are doing that again. We're showing another way, or we're trying to add descriptively to where there are limits to the claim that insurance can act as a governance, as a governing agent, right? There's no claim that insurance governance is efficient, that it's altruistic, right? We're not trying to get to the right amount of precaution. Insurers are simply trying to limit their own losses. One way to square those two competing ideas is what I've said a bunch of times today, which is that insurers can use this as a really cheap way to possibly mitigate risk or mitigate loss. You don't have to change your sprinkler system or update your technology or install new laundry systems to get rid of bed bugs or review your springs on your trampoline. All you have to do is add a clause that, as Peter said, no one's going to read. So it's a small ask and an easy give in an insurance relationship that could have many other sticking points. So it's no wonder that insurers find it such low-hanging fruit. So last thought is this. If insurers are looming in the background of consumer contracts, they might be in a more appropriate party to sort of start pressuring to reform this boilerplate. Scholars have long tried to constrain the use of this boilerplate because they view it as aversive. But insurers might be a place that we can go to learn more. Insurers might have key data about whether the terms are in fact aversive. Do they really help or harm consumers, and in what ways? If they might be able, and if that's true that they're aversive, maybe we could lean on insurers to modify the worst parts of the terms. Admittedly, insurers have no incentive to do that. But a regulator seeking change might find that the insurer is a useful place to start. So, for example, could insurers help remove truly unenforceable terms in contracts? There's Hoffman has written an article where he shows that lots of commercial leases, when I say commercial here, I mean residential leases by commercial entities have truly unenforceable terms within them. Maybe insurers could help sort of help constrain that bad action. It's difficult to imagine this as a project, but it does offer new ground for contract scholars to plow. So with that, I'll just say thank you, and I hope some of you have some questions, and that was really fun. Okay, wait, I'm going to stop sharing. Okay.
Okay, so queue is open. If you want to get on the queue, I'll just open it up for a minute before jumping in. All right, so thanks. There's a ton there, and in light of what you're talking about, the sort of growing pushback against the insurance's governance literature, it seems like one of the ways one can think about that is just that, like, look, the insurance's governance literature, in a way similar to the sort of law and economics of insurance literature, assumes a very efficient operation of the insurance companies. You know, that like any savings is going to get priced in and then like through competition passed on to the consumer, and that just like our ability to theorize about insurance companies and their impacts on society is hampered by the fact that they're just really inefficient. Like it just, you know, the theory doesn't accurately capture all the different kind of inefficiencies or frictions, transactions costs involved. And it seems like that's one way to interpret part of what you're saying. And I wonder whether that resonates with your understanding of what's going on here.
So Travis, I agree completely. I mean, what I'd say is, yeah, I agree. But what I actually think is that most of the people who have written about this at all have been very careful to limit their findings. So when I wrote about the legal professional liability context, we saw lots of sort of impacts, real world and others, that were coming from insurers because law firms were thirsty for the advice. And it's not that it's efficient, right? Like, and I don't think we were ever claiming that it was efficient. We were claiming that law firms, I mean, and a good example is that like basically LPL insurers see conflict of interest as a winning argument, even though it's irrelevant to a malpractice claim. So one of the things they encouraged is really tighter conflicts checking and really tighter checking. They also saw like bankruptcy as really bad. Any risky entity that goes into bankruptcy is going to lash out for any money they could find, including a malpractice claim. But that might mean that you're going to tighten your controls on who you insure. That might not be good for the law firm because they're not going to get that new startup that's going to become Amazon. Or you might sort of pass over a conflict that might be a waivable one, right? So, but we said that my point is, I think that most of the scholars who have written have said so in a way that is, very careful. And I think here we're saying something similar, and we're adding to that sort of claim, which is here's lots of ways that I think people that are writing in the insurance as governance literature have to be careful when they're thinking about what is being done. So I say yes and to everything you're saying.
Great. Larry, you're back.
Thank you. So hi, Rick. You're speaking my world. I'm a broker and a claims professional, so a lot of the comments you made are are interesting and somewhat familiar. But you don't come out and say it directly, but there's an implicit view that there's somehow a conflict between the insurer and the insured when it comes to boilerplate. And it seems to me that the chief beneficiary, like the insurer wants to mitigate damage, the insurer wants this. It's really the insured who, like you mentioned, often have high deductibles, retentions, they're dealing with reputational issues. They're the ones who have uncovered losses. And I bet you all the boilerplate was written by the trampoline lawyers or Google or whoever. So are you suggesting there is some sort of conflict or difference of interest between the insurer and the insured when it comes to boilerplate?
No, not at all. I mean, I'm sorry if I was unclear. I think actually in most situations, the insured is happy to adopt the boilerplate for all the reasons that Peter said. But the question for sort of the contracts crowd out there is actually a different one, which is, are these things actually valuable? Like, are they really saving money? And it's hard to know. And then who's keeping that? Who are keeping those rents? Like, if it's creating windfalls, who's getting the benefit? And that's really unclear. I don't actually think that there's a conflict there. But I do also, and then sort of the other side of that is who's producing it. My instinct too, Larry, was that like Google's lawyer is producing all this stuff, but like those GCs we didn't talk to them, but in other papers have basically said, we don't have time to mess with consumer facing contracts. We just we're so busy with other stuff. Like that's not so unlike they do have some evidence of this in the commercial context in business, like in mergers, there's lots of boilerplate, but there basically lawyers are touting how good their boilerplate is as a way of sort of marketing, but that's not what's to future clients, but that's not what's happening here. So I'm not sure. I just don't know is the answer to that. And I would love to know more.
Well, I just think that it's probably one of the lower things on the priority when it comes to influencing insured's behavior and pricing. I mean, you mentioned cyber being a huge one, but there's a million different things. I mean, what's interesting to me would be a study where there is a conflict is the insurer's influence on the defense bar. They're pushing down rates, controlling litigation, really influencing how claims are settled and or not settled. That'd be an interesting area of study. I don't know if there's anything out there, but I appreciate your views.
You and I can write it later, Larry.
Okay. Well, I'd like to talk to you more about this.
All right, Peter.
Great. So thanks very much. I mean, if what's the cost? Like literally the cost of a paragraph of boilerplate. Because if it's very low, then sort of following on what you were saying before on my previous comment, then like you should just insist that it be there, and you don't even care whether it works. If it costs me a nickel's worth of time and effort to put this in, like, well, as long as it does at least a nickel's worth of benefit, and it probably will do that, whether it deters or whether it actually legally is enforceable and eliminates loss, then yeah, I'll put it in. So why would insurers even know? Like they should just be going around saying, hey, this is the cheapest thing we can possibly do. As you said, it's much easier than saying you have to check your trampoline springs every week or, put in a new, I don't know, air filtration system or something. It's basically free. So why doesn't everybody want to do this all the time. And if I can add a second question, sort of related, it also plays on Travis's earlier one. I wonder how much of the problem with insurance companies not figuring this out is that like the underwriting professionals who are presumably doing the pricing and the claims people aren't lawyers. So they're not even like probably reading the contracts. They're just seeing like, oh, we got a claim on this thing. They're not thinking that could have been prevented if only we'd had some language somewhere in a document that we didn't even see. And so how much of this is like parts of the insurance company not talking to each other? Did you hear about that?
So I actually think, I was actually surprised. So there are lots of claims professionals that are lawyers. That's the first thing. So, right, and they are very much aware of this. And then included in claims professionals is, of course, claims attorneys. They're the ones that are handling it for the insurer. So they're also reviewing this stuff. And also underwriters were aware of it. So it's, I don't think there's a blind spot in that way. But it might be that it is not, in a world where we have limited time and limited resources, we just don't know how we're gonna, how can we can't review everything and we can't encourage everything. We can only do so much. And so I think it's perfectly plausible to say that one of the reasons they're not encouraging this more is that it's low value in certain industries.
But again, it's net, right? So it's low value, but also
it's low
very,
cost.
very low cost.
I agree with that completely. And so I think that's part of why it's probably proliferating, right? I think that's right. And that's what Dave and I have said, yeah. So I have a question in the comment question in the chat, which is, can we get a copy of these slides? I'm happy to send the slides to Peter if that, I don't know what to do beyond that, but I'm happy to do that.
Great.
I got another question from someone, but I don't quite know to what it is referring. It says, am I including third parties in the benefit to the insured? But I don't remember what I said about benefit to the insured. So, and you sent it to me directly, and so I don't want to out you, but if you have a question, I'm happy to answer it.
That was Raina, and she sent it to everybody, I think.
Oh, she did? Oh, okay. I thought it was sent to me directly. Okay. So Raina, I don't know what you mean by that. I'm sorry. I thought it was it just says new message. How does the boilerplate benefit third parties and their attorney? I need a hypo to sort of lock in on that. Actually, I'm struggling to see the idea. You might be asking, let's see. You might be asking, like, if you are a third-party beneficiary. I'm trying to think about like when this would be true. It's not like, if you buy an iPhone, who is the third-party beneficiary for that?
Okay, Raina's decided to pass.
Okay, sorry, I'm trying.
Injured parties.
I wish
she says injured parties.
Oh, I wish I were clever enough to come up with the right answer for that one.
Other folks want to jump on the queue?
Neil.
Yeah, I just thank you. I enjoyed your paper. I had a question about, in my world dealing with large E&O policies, panel counsel is always involved and their rates are really low. And it just seems to me in the right commercial general liability context, the carrier would be wise to say, hey, spend 5 hours with our panel counsel, have them go over, your main consumer contracts. And you do that once every couple of years, and I'm sure it pays for itself many times over. It just seems way too easy to not be done. And I was just curious what you thought about that.
No, I think that's right. And the slide I had with the sort of the information ecosystem, I think is just that. I do think we hear, claims counsel isn't going to get on the line with the underwriters or, and it has to, among the many things that are mysterious to me, titles in insurance companies are among the top. So I never know exactly who is, does what in an insurance company. But, for a claims person to get to the sort of the top part of an underwriting organization that's then going to sort of proliferate that down through the underwriters, you can't do it all the time, but certainly, at some point these messages are getting filtered back up. And we heard claims counsel tell us that they were doing just that at moments. I think that's right. But also, Neil, if you're in the industry and you think there are people that we should talk to, I would love to talk to them. Reach out. I'm very findable.
Kyle?
Yes. So one, I'm in the industry, I guess. I'm a policyholder side coverage attorney. So I think I have some unique insight into this, particularly if you're looking for an area, New York construction insurance.
Yeah.
There's a lot of this type of stuff going on. And one aspect I think, which is funny, is getting the insured to adopt these provisions. I think it feels like only half the battle. Because if you draft the best waiver for them, you're still relying on someone to make sure that every customer is signing the waiver before they get on the trampoline park. And so you can run into problems if the 16-year-old cashier at the trampoline park is not doing their job, particularly if then you have a policy that says we're not going to cover your claims if you don't have your people like do all your, use the waiver that we've provided for you. And I wonder if that's part of the analysis as to why this is not promoted more.
Oh, I mean, I don't know. It's a nice thought. We definitely talked to folks who complained, not necessarily in the consumer context, but in the business to business context, that they had like really great contracts that they never got signed. like in the construction industry, where they were like, we've got the tightest, waivers and risk transfers, and then they just do everything with a handshake. And it's like, how do we ensure that, right? And so I think that's real, and I think that that's true. Although, in today's day and age, in the trampoline park settings, I don't know, my kids are post trampoline park phase, but I couldn't get through the door without pushing on 42 touch screens and signing 82 email contracts before I even got there. So I don't know. I mean, I think it's a little bit of both end on that one.
We have one question in the chat and also a comment from Mark Mayerson about MGAs, I guess, being the best place where that kind of cross-fertilization happens.
That makes sense, I think. Yeah. Are these clauses being added to both commercial general liability policies? No. Sorry, just to be clear, they're not being added to insurance coverage, right? So the clauses we're worried about are not clauses that are in insurance contracts, but rather clauses that insurers that policyholders might have with their customers. So here, not the insurance contract between the trampoline park and the liability insurer, but between the trampoline park and the consumers. But Raphael, just so you know, I had that question about 70% of the time from my respondents. I had to get them on track. No, I'm not worried about the insurance contracts. I'm worried about this other thing. So it's very, very common.
I just had another question. This is pretty open-ended, but I'd be interested in your remarks on what it's like doing this kind of qualitative research in this industry, like what quirks there are, how you go about trying to get access to the relevant people. I'm in the little bit I've tried to do that, I don't know whether it's unusually difficult. It's not easy by an objective standard, but if just as a qualitative researcher in this area, if you have any sort of thoughts or tips or learnings,
this is the second time I've done it. We did it with the LPL stuff, and now here. And I found this one much more challenging. So just sort of as we talked about before I got on, I think there are two basic things that are true. I mean, one is that in the legal professional liability insurance market, it's a much tighter market. And so once I got in, it was easier to stay in and get to people. And also, I was also trying to talk to lawyers and general counsels of law firms, and they like to talk, and then they were happy to hook me up with their insurer. So it was easier that way. Here, it's a much more sprawling question. It's sort of trans-substantive. I'm not worried about gun liability or LPL or securities class actions. I'm just interested in boilerplate, and boilerplate is coterminous with the economy. And so it was very hard to get our hands around like who should we talk to? And sort of, I think the other thing that was hard about this was, so it took us a lot of time to narrow in on that question. The other thing that I think is true is that in the last 5-7 years since I stopped doing the LPL stuff, maybe more, I can't remember, I think it has become, people are getting more spam emails. And so they're less likely to take emails over the transom. And they're more likely to send things through general counsel, which is basically 90% of the way to a no. So, yeah.
Well, great. We're grateful for all the work you did, and it's super interesting paper. Thanks for sharing it with us.
Thank you. Thanks for having me.
Hope to see you all
Yep.
again.
Thanks a lot. Come back
Thank
soon.
See you all in a
Bye,
couple
Rick.
of
Thanks.
weeks. Bye.
Yeah, and Rick, if you want
Thank
to send
you.
me the slides, anybody who wants a copy of the slides can just email me.
Will do.